Hello and welcome to tonight's Advocates Speak event. I'm Praveen Fernandez, the Associate Director of Programs at the American Constitution Society for Law and Policy, otherwise known as ACS. For those of you who are unfamiliar with ACS, we're a national network of lawyers, academics, policymakers, and law students dedicated to ensuring that dedicated to ensuring that fundamental values of dignity, equality, and liberty, and access to justice occupy their rightful central role in American law and policy. In addition to our substantive work, however, we're also about the business of building and fostering a progressive infrastructure. This involves collaborating with individuals across the country. These individuals include longtime friends of ACS at Jones Day, such as J.T. O'Hara, Herbert Hansel, Julie McAvoy, Leslie Overton, and Catherine Stern. Again, thanks to Jones Day for agreeing graciously to sponsor this event and for fostering this discussion on this important topic. Okay, on to the panel. While our moderator will have the pleasure of introducing the panelists, I have the honor of introducing our moderator, Catherine Stern. A true recitation of her accomplishments would take more time than I have, so I'm going to give you the highlight reel instead. Catherine, who practices law at Jones Day, has significant experience in national security law and the protection of fundamental human rights. Her amicus clients in the enemy combatant cases include Human Rights First in Padilla and the National Association of Criminal Defense Lawyers in Almari. She's a graduate of Yale Law School, a Marshall Scholar, and has a PhD in literature from Princeton. I thought one of the most interesting things is it's not just her legal practice that has an international focus, but Catherine also taught world literature in Alaska for many years before practicing law. So without further ado, Catherine, thank you.
Thank you, Praveen, and also Caitlin McClune and Ann Donovan of Jones Day for helping to organize this. I want to start by welcoming and acknowledging all of you for coming here and thanking so many of you who have made tremendous commitments of time and energy to these issues. I know that many of you here, from Supreme Court advocates to first-year law students, scholars, and first-year associates and reporters and congressional staff, that many of you here have worked to gather the detainees' stories, to expose their conditions, to research their legal rights, and even to travel to their families' countries to contact their families. And many of you here have joined the vast teams of advocates that have taken up their cases, and perhaps even the people who carried the poetry of the detainees out of Guantanamo with great trouble so that we could hear their voices are here tonight. We've all done this work because there still remain 305 people in Guantanamo suffering in arbitrary and indefinite captivity. And also because our country's traditions and honor are at stake in these cases. Because we realize that by denying the ancient right of habeas review, we've reached a turning point in our constitutional history. I thought it might be helpful for the panel if I take a show of hands to see how many people actually attended or have heard the oral argument this morning. All right, well, to summarize very briefly, the questions that were before the court were, and I'll try and make this simple, and I know that the panelists will go on to get into the nitty-gritty. Whether, as the D.C. Circuit held, the Military Commissions Act of 2006 withdrew federal court jurisdiction over pending habeas appeals, as well as new habeas appeals of Guantanamo detainees, specifically and unambiguously. And if it did so, whether that withdrawal of habeas is constitutional, given the nature of U.S. custodianship of the detainees and of U.S. control over Guantanamo, and whether withdrawal of plenary federal court habeas review is constitutional given the limited nature of the alternative review scheme that Congress has approved. That is a scheme whereby military personnel conduct a review of their own records, known as a Combatant Status Review Tribunal, or CSRT, to make a formal finding of the detainee's enemy combatant status. And then the D.C. Circuit may review, under a provision of the Detainee Treatment Act of 2005, or DTA, whether the CSRT's standards and procedures are consistent with the Constitution and laws of the United States. But apart from the availability of habeas review, these cases demand our attention because the prisoners at issue are not convicted criminals, as in the Kieran or Eisentrager cases that the government relies on. They have readily verifiable stories demonstrating their innocence. Most of them were never involved in combat or even armed when captured. The Seton Hall students estimate that 95% of the detainees were turned over to the U.S. by bounty hunters, provided with incentives of $5,000 or more. And there is also an unusual number of detainees' cases that are being stayed pending this decision, including cases regarding the CSRT procedures, as well as Hamdan's military commission appeal. And finally, one more extraordinary thing about this case is that we're about to hear about an oral argument in cases that were denied cert in April. So last April, Justice Ginsburg, Breyer, and Souter, is that correct, were interested in hearing these cases. But Justice Stevens and Justice Kennedy signed on to a denial of cert, and they provided at that time their reasons. And then in June, in a quite remarkable reversal, they joined the three other justices for a 5-4 majority that was required to reverse a denial of cert. So that is how the curtain opened this morning on the Supreme Court review of Boumediene and Al-Awda. We have 5 to discuss that they brought to the Court's attention. Paul Wolfson, counsel to the Boumediene petitioners, David Cinnamon, counsel for the Al-Awda petitioners, Ketanji Brown-Jackson, who will speak about the former federal judge's brief, Cecilia Wong for the ACLU, and Tim Lynch for the Cato Institute. You'll find our speakers' tremendous experience and accomplishments on the biography sheets that you had coming in. And it's an honor to welcome you here, all of you. And I join Praveen in thanking you for coming out after. We'll hear from each one of you in turn, Paul Wolfson, and then David Cinnamon, then Ketanji, Cecilia, and Tim. And then we'll begin a conversation among you and then take questions from the audience. And for the audience, I want to invite you to feel free to get up and refresh your drinks during our discussion, and we'll have mics for you for the question period. And then after that, we'll have a reception with hot hors d'oeuvres. So thanks, everyone, for coming.
Thank you. It's a great privilege to be here, and again, I want to thank Jones Day again for this very nice venue and hospitality. Let me give you a few impressions about the oral argument from the perspective of somebody who was sitting there at the council table today and kind of furiously passing notes to the advocate. As was discussed earlier, there really are 3 issues in the case, and which are sort of taken in sequence. The D.C. Circuit ruled, and got no farther than this, the D.C. Circuit ruled that when Congress passed the Military Commissions Act, and in that respect completely eliminated habeas, there's a debate about whether they actually did, but I'll assume they eliminated habeas for the people currently in Guantanamo and replaced it with the Detainee Treatment Act review. So the first question was whether that raises any constitutional question at all under the suspension of habeas corpus clause of the Constitution, because as the D.C. Circuit pointed out, the question was whether non-citizens detained in Guantanamo have any constitutional rights to invoke the habeas corpus clause So if they didn't, there's really there's not really any constitutional issue at all, and the detainees are, thankful for what they get from what Congress offers them under the Detainee Treatment Act. So that's sort of the first question. The second question, if you answer yes, they do have constitutional rights, then the second question you get to is, okay, is what Congress gave the detainees in the Detainee Treatment Act, but simultaneously took away from Habeas, was that a fair exchange? Did Congress give the detainees the moral equivalent of Habeas as required by the Constitution, whatever baseline the Constitution requires for habeas corpus? And then if you answer that question no, that is to say, if you conclude that the detainees did not get a fair exchange, and so they're entitled to kind of proceed as if they were on habeas corpus. And remember, these all are habeas corpus cases that were filed in the U.S. District Court. Then you get to the question of, okay, I'll let that pass. Then you get to the question of, is the detainees' detention illegal? Have they, do they have a claim on the merits? And that claim itself has several subparts, and different groups of detainees have different claims. All of them, I think it is pretty fair to say, argue that the procedures that they were, the administrative/military procedures that they received at Guantanamo, the famous CSRTs, are unconstitutional because they do not comply with basic tenets of due process. Others, including our clients and some others, argue that the substantive standard that the government applied to determine whether they are enemy combatants does not match what goes beyond what Congress authorized when it authorized the authorization of use of military force against Al-Qaeda. And then there are a whole variety of other claims, some involving the Geneva Convention and various others. So we'll think of that as kind of 1, 2, and 3. Interestingly, there was practically not a word said about 3 today. So, and of course the D.C. Circuit didn't even get past 1, much less to 3. So, although I guess I'm always hesitant to guess how, what will be decided and how a case would come out, I would bet that the court is not going to reach issue 3, and the real meat of the decision will be on questions 1 and 2. That is, do the detainees have constitutional rights at all? And if they do, was the Detainee Treatment Act a fair trade for the constitutional rights to habeas that they have? And if the court were to conclude that they do have rights and the act is not a fair trade, then presumably the case would go back to the lower courts or to the D.C. Circuit in the first instance, I guess, to rule on the merits. My impression from question 1, my impression about the court's the various questions that were being asked on the first issue, that is whether the detainees have constitutional rights at all, my impression was that most of the justices seemed to think that this was reasonably well settled by the Supreme Court's decision several years ago in Rasul, which was basically this case in an earlier, but before Congress enacted the Detainee Treatment Act, all of the detainees at that time were proceeding just under habeas corpus. The government had argued the habeas corpus statute doesn't apply to people in Guantanamo, and the D.C. Circuit agreed with that, and the Supreme Court reversed and said, yes, it does apply, but in so concluding, the court undertook a kind of a lengthy exegesis of where the writ of habeas corpus had extended at common law and concluded that it would apply even to certain non-citizens held by the United States outside the sovereign territory of the United States. And so even though that was not squarely a constitutional holding in Rasul by the majority, it certainly had these sort of strong, I think, constitutional overtones, and it would not be difficult at all, I think, for the court to say, as we concluded in Rasul, et cetera, et cetera. There obviously are people who dissent from that point of view on the Supreme Court, including Justice Scalia, and I think Chief Justice Roberts clearly was indicating that he felt that the President and the Congress had concluded that Guantanamo was not part of the United States, and so that should be respected as a political decision. Justice Kennedy in Rasool, not only, he didn't join the part of the majority opinion that said that the statute applied. He actually, in some sense, I think, went further and said that he thought that as a constitutional matter, the writ had to apply to Guantanamo. So I think all he would have to do is follow his own opinion, concurring opinion in the earlier case to reach that decision. So, although there certainly will be a lot of activity on the first question, I think I see the court can see its way clear to ruling in our favor on that one. I think the real meat of the case today was on the second question. That is, was the Detainee Treatment Act a fair trade for habeas corpus? And here it is this kind of, in some sense, a big uncertainty because the Detainee Treatment Act has not been applied by the D.C. Circuit in any case yet. It has been construed in some important respects, but it certainly hasn't been, given all its metes and bounds. And the government's position all along has been, well, let's wait and see what the D.C. Circuit says the Detainee Treatment Act actually holds, and then we'll be able to kind of map it up against habeas corpus and see whether it's a fair trade. I think it's fair to say that the reception that argument got today was mixed. It's certainly, there's certainly, I think the court is certainly not desirous of engaging in a sweeping holding, but I certainly did think they indicate, especially in questions by Justice Kennedy and Justice Breyer, first of all, some discomfort at the fact that the cases have been pending for so long in the courts, and yet there doesn't seem ever to kind of be any time at which anybody will actually reach any ruling on the merits, which is contrary to habeas corpus's kind of essence of being a speedy remedy. And then I think there was some discomfort at the fact that the government seemed to think that there were lots of claims, or certainly some important claims, that couldn't be made under the Detainee Treatment Act, both legal claims and factual claims. And and I think the court was really paying extremely close attention to that because they were really trying to question both sides very carefully about, well, what exactly can the D.C. Circuit hear on the Detainee Treatment Act? And I feel that the General Clement, although he's a fabulous advocate, I don't feel that he put the court's unease at rest about whether the Detainee Treatment Act is a fair trade for a habeas corpus. And if they don't feel that it's a fair trade, then, then habeas corpus would have to remain. Why don't I stop there? And those are my impressions from sitting there. So,
okay. And thank you, Paul. And I want to reclaim the pleasure of introducing you because I think I gave it up too quickly. And thank you for that wonderful recap. And I wanted to just acknowledge that. No, actually, I think I will let people know that that Paul has received the Attorney General's Distinguished Service Award for his 8 years in the Solicitor General's office, as well as argued 19 cases before the Supreme Court. And in addition to being counsel to Boumé Diène right now, he is also well known to Jones Day in his current representation of the Texas chapter of the NAACP. And now we'll go on to David Cinnamon, who is senior partner at Pillsbury, Winthrop and Shaw and Pittman, and he has 34 years of appellate experience with all varieties of complex civil litigation, and he's in addition director of the Washington Lawyers Committee for Civil Rights, and he's speaking as counsel of record for the Al-Odar petitioners.
Thank you, Catherine. Thank you all. First of all, I want to commend all of you for coming here, not only fighting your way through the snow and sleet, but fighting your way through the maze and obstacle course that it took to get from the fifth floor up here. You clearly have to be interested in the subject to be here. And second, I want to acknowledge and recognize my colleague who worked with me on this case, Matthew McLean, who is a principal drafter of the Al-Odar briefs. And also the reason I want to recognize him is he pulled one of the most brilliant ploys I have seen in this case. His mother, who is also an attorney and is with him tonight, really wanted to see this argument. Recognizing that it would be impossible for her to get in, back in August, right after cert was granted, and we got some early indication of when the argument date might be, Matthew arranged for her to apply for admission to the Supreme Court bar and called the marshal and had the admission date scheduled for today. So not only did he get her into the argument, they got front row seats, and Matthew got to stand up beginning the argument and move the admission of his mother for the Supreme Court. It's exactly that kind of creativity and persistence that Matt has brought to this case. Let me give you a couple of observations. I'll start with a couple of predictions. First of all, my prediction is that this will be a 5-4 decision. And if I were to stop there, it would simply confirm what my colleagues refer to as my flair for the obvious. But I also want to predict, and I do not think that this is just wishful thinking or advocacy speaking, that it will be 5-4 in favor of the petitioners. I do believe that Justice Kennedy will come out our way. My sense from the argument is that 8 of the justices pretty much have their minds made up. And I do agree with Paul that at least 2 of them, Chief Justice Roberts and Justice Scalia, will agree with the majority in the D.C. Circuit below that the detainees do not even have any constitutional rights to assert, so they won't even get to the second question. And probably Thomas and Alito will go along with that. Although I'm not sure. I also believe that the 4 members of the Rasool majority who remain on the court, Breyer, Souter, Ginsburg, and Stevens, will rule in our favor. The reason I believe that Kennedy will come out our way is both from his prior conduct, that is, the fact that in Rasool he wrote a concurring opinion that joined with the majority. And to me, the analysis in his concurring opinion applies even more strongly to the present situation. So that's one reason. Number 2 is his extraordinary reversal of position in this very case, in which first he joined with Justice Stevens in denying cert, and then on the last day of the term joined with Justice Stevens in agreeing to grant cert. And when we get to the question and answers, I'll be happy to give you my speculation, semi-informed speculation, as to why I think he did what he did. And third, I think that the arguments today were helpful, or will be helpful, in persuading him. I think his questions clearly indicated an ambivalence. I think, as Paul said, that he decided in Rasool and still remains of the view that there is a right to habeas that the detainees have, and he is struggling more with the second question of whether the remedy, that the narrow procedures for review that Congress provided in the DTA will be an adequate substitute. And he asks questions that suggest both that he's concerned about having to decide that issue before the D.C. Circuit has an opportunity to look at it and rule more closely, also has a concern about the impact of granting full habeas relief. But he also asks questions that to me suggest that he's very concerned about the delay, the fact that no one has come close to having a hearing on the merits, and he's troubled by the narrowness of the remedy. And also, finally, I think that for those of you who were at the argument, you know this. For those of you who weren't, I encourage you to listen to the audio. Seth Waxman, who had a wonderful argument throughout, had an absolutely brilliant closing on rebuttal, one of the most powerful and best closings I've ever heard, in which he really brought the court back to what's at issue in this case. It's about human beings, in this case a particular human being, as to whom there is absolute evidence of innocence. And that absolute evidence of innocence was not brought to the attention of the Combatant Status Review Tribunal, and cannot, no matter how you tinker with the DTA, ever be brought to the attention of the court so that this man could be found innocent. I thought at least it was tremendously powerful. Justice Kennedy was listening very carefully, and I believe that that was the coup de grace that will bring him around.
Thank you, David. Ketanji Brown-Jackson is going to speak next. She's of counsel at Morrison Foster, and she focuses on appellate and Supreme Court litigation. She's been there since last summer, but before that she was a federal public defender in the D.C. Appeals Division, and in that capacity she was contacted by Center for Constitutional Rights, and she did their training, and she's represented 3 Guantanamo detainees on their DTA and habeas appeals. And she's going to tell us about the CSRT process and what's up with that.
What's involved.
What's wrong with it?
Well, hopefully my comments will be brief, because the brief that I had the pleasure of working on behalf of former federal judges was the amicus brief in the context of this case that focused on a relatively discrete issue. And that goes to question 2, as Paul laid out. It's the concern that, unlike habeas corpus, the DTA process does not appear to be designed to allow the reviewer to really assess the reliability of the government's evidence by determining whether or not that evidence or the statements and testimony that the government presented in support of the enemy combatant determination was extracted by torture. The sort of torture issue, I did not have the pleasure of getting to the court this morning, but I understand that torture was not specifically addressed at the argument, but it is an undercurrent in a number of the cases, and really serves as one pretty clear example of the way in which the DTA process differs from habeas. It's sort of the big picture is that in a habeas context, the court really is able to have a searching, factual review of the bases for the government's, or the executive detention and the government's evidence. And the DTA process, the CSRTs and the DTA, really don't provide a mechanism for having the same sort of searching factual inquiry by a neutral fact finder when assessing whether or not the person's detention was legal. The former federal judges, 20 of them signed on to the brief. It was, judges, Article III appointed judges appointed by 6 different presidents, so it was very non-ideological. And they felt quite strongly that if you're going to have an alternative system for judging the legality of an executive detention, that system has to enable a person who is charged with making that determination to evaluate the reliability of the government's evidence. And traditionally, our brief sort of had 2 main components, and the first really went through the historical aversion to torture, the fact that torture has been illegal in our Anglo-American tradition for centuries now. We talked about the Star Chamber as a relatively aberrant period in which even then torture was used quite rarely and not considered to be under the law. It was a process that was used by the monarchy outside of the law. And so for centuries now, torture has not been allowed, and courts have, even under the common law, determined that statements and testimony extracted by torture would not be admitted because it was considered to be unreliable and also degrades the process of justice. And yet, in the context of this procedure, there were serious allegations that the CSRTs were relying upon evidence that had been extracted by torture. And the judges were quite concerned about that. And it should be noted that this really is not a hypothetical concern, that according to a report, there were 18% of the Guantanamo detainees alleged that they themselves had been victims of torture. And that's, not counting the numbers of other people who may have been tortured or coerced into giving statements that implicated the Guantanamo detainees. And so just quickly touch upon the sort of nitty-gritties of the process. The process did not appear to work to enable the fact finders to root out this kind of evidence, because at the CSRT level, which is the my understanding is that the Department of Defense, when it captured these people, originally went through some sort of internal review of their own and designated them enemy combatants. And after the Supreme Court said, no, you really have to do more than that, the CSRT process was created, wherein a panel of people, military people, I believe, are selected to review and determine whether or not the people have been properly designated as enemy combatants. In the CSRT panel process, there is no rule of evidence that is applied to exclude any evidence based on hearsay grounds or anything else. In fact, the panels can rely on anything, any evidence that they deem, quote, relevant and helpful to a determination as to whether or not the person is an enemy combatant. And at the time of the CSRTs that occurred, that are at issue in this case, there was really no need to assess whether or not torture had occurred. CSRTs had no mandate to assess whether or not torture allegations were had any truth to them at all. There was also a presumption that the government's evidence was, quote, genuine and accurate. So the panels went into this looking at, statements that this person, had done such, thus and such, and had to give that statement a presumption of accuracy, and really had no basis for assessing whether or not the person who made that statement had been tortured. I could go on and on in terms of the details, but it's important to note as well that there really was no process for the detainee himself to establish that he had been tortured, even if he had such an allegation, because he had no lawyer. In these cases, he didn't have any access to the classified information that comprised most of the allegations in most of these cases. So there was really no way to challenge the statements that were being made. And so really, at the CSRT level, there was no real hearing or fleshing out of facts regarding the reliability of the government's evidence. And then you go to the D.C. Circuit level under the DTA, and the question becomes whether we can get to the bottom of torture allegations at that level. And again, the concern is that the statute really does not provide a mechanism for the D.C. Circuit to flesh out whether or not the evidence that the government was relying on was extracted by torture. This is sort of a touchy subject to some extent, because, as Paul mentioned, there really hasn't been a situation in which the D.C. Circuit has applied the statute yet. So the judges kind of had to look at the statute, wanting not to make a definitive statement that the statute did not allow the D.C. Circuit to exclude torture evidence, because there could be a future case in which the D.C. Circuit looks at the statute and says, no, there's room for us to do that, and obviously it would be in the judge's, interest to interpret the statute in that way. So the judges had to say, looking at the statute, it appears as though there's no mechanism for a D.C. Circuit judge to get to the bottom of torture allegations. And anything else I wanted to say? So it actually turned out to be quite a wonderful experience for me personally to work with so many former federal judges and on a very, very important aspect of this case.
Thank you. Cecilia Wong is a senior staff attorney with the ACLU, and she has also served in the Federal Public Defender's Office in the Southern District of New York, and also on the Northern District of California's Criminal Justice Act Criminal Defense Panel. Like Ketanji Brown Jackson, she's also clerked for Justice Breyer, and she's going to talk about ACLU's case in Boumediene. ACLU focused particularly on the issue, going back now, to whether whether it's constitutional to have a habeas stripping provision or not. Thanks.
Thanks, Catherine. I had two interesting conversations today after attending the Supreme Court argument that I want to convey to you, and then a challenge. After the argument, I was interviewed by a couple members of the ACLU's media department who wanted me to do a podcast for a general membership for lay people. And they said, look, you got to keep this non-technical. I mean, I guess you have to say the words habeas corpus, but please, nothing other than that. And then I went to lunch with a friend of mine who is a graduate of an Ivy League law school, and she said, what case were you here for? I saw something in the paper about Guantanamo. What case is that? And so it's astounding, actually, that so many informed and educated Americans aren't really paying attention to this case and to what's going on with the administration's policy with respect to Guantanamo. So I want to challenge all of us in the room here who obviously care and are engaged to go out there and spread the word and, tell your mom about it. Well, some mothers in the room already know about it, but, those of us whose mothers aren't here, spread the word, because I think it's obviously tremendously important. As Paul and David explained, most of the briefing by the parties in this case and the argument in the case centered on the issues of whether the suspension clause applies in the circumstances here with the Guantanamo detainees, and then whether, if it does, the DTA procedures that Congress has enacted are an adequate substitute for habeas. Now, those issues are tremendously important, but the ACLU amicus brief that we submitted really was concerned with a much broader statement in the D.C. Circuit's opinion. And that was the following. Judge Randolph wrote, "The Constitution does not confer rights on aliens without property or presence within the United States." Now, that's astonishing. It's astonishing because, number one, it's much broader than the issues that are involved in Boumediene and the other Guantanamo detainee cases. And it's also astonishing because it is unprecedented as a categorical rule that non-U.S. citizens outside the United States who do not have property in the United States have no constitutional rights. The Supreme Court simply has never so held, contrary to what the government has said. And so the ACLU came at the Boumediene case from two different angles, really with 10 individual people in mind. Those were our 9 Iraqi and Afghan clients in our case of against former Secretary of Defense Donald Rumsfeld, challenging the Defense Department's policies and practices of torturing people in U.S.-run prisons in Afghanistan and Iraq. And also our client, Khalid al-Masri, who was snatched off the streets of, I think, Macedonia and taken by the CIA to a secret location where he was tortured and detained for quite a prolonged period, even after he was found not to have any links to terrorism or any kind of criminal activity. So we came at the case of Boumediene thinking about the D.C. Circuit's extraordinarily broad statement that the Constitution does not confer rights on aliens without property or presence within the United States. And we took a look at the Supreme Court precedents on the subject broadly of whether non-citizens have rights, and started with the insular cases, which were cases during America's period of imperial adventures, when we first went into Puerto Rico and other places, the Philippines, etc. And the Supreme Court evaluated different individuals' claims under different provisions of the Constitution in various cases over the course of the 20th century, and evaluated them one by one, looking at the individual circumstances of what the right of the right that was asserted, of the nationality of the person asserting the right, of the location of the alleged violation, and other factors, and made its determination on a case-by-case basis, applying common sense and constitutional doctrine. And then we turn to a 1957 case called Reed versus Covert, in which some spouses of U.S. military who were serving in foreign countries in Japan and Germany were charged with murder by court-martial, even though these were civilian spouses, and convicted and sentenced to death. And in that case, Justice Harlan said in his concurring opinion, look, the question in this sort of case is not whether the Constitution does or does not apply outside the United States. It's really a question of practical circumstances, and you need to look at each case on its own merits and determine whether the asserted right should apply or not. Now, Justice Kennedy, fast-forwarding a couple decades to 1990 in the case of United States Verdugo Urquidez, cited Justice Harlan's concurring opinion and seemed to agree that the test in any given case of whether a constitutional provision should apply is whether it be impracticable and anomalous to do so. And then the Supreme Court majority in Rasool, we argue in our amicus brief, also endorsed that test by citing to Justice Kennedy's concurring opinion in Verdugo Urquidez. So the aim of our amicus brief is to remind the court that we're not talking here just about Guantanamo. And, you know, just to state the matter clearly, we're concerned that the court in this case may hold for the petitioners on grounds that would be narrowly limited to the unique lease agreement between the United States and Cuba that applies to Guantanamo, and do some violence to the Constitution and the rule of law in other places. So that was the basic idea of our brief. I'm sad to say that the only indication I got from the bench today about whether the court would buy our argument or not was the Chief Justice saying in a tone of disbelief to Seth Waxman, are you saying we need to apply some kind of multi-factor test to determine whether the Constitution should apply? And so we didn't get much comfort from the argument, but I hope that someone is listening.
Thank you, Cecilia. Last we have Tim Lynch, who is the director of the Project on Criminal Justice at the Cato Institute. And he has filed amicus briefs for the Cato Institute in Hamdi versus Rumsfeld, as well as Boumediene and several other Supreme Court cases. He's served on the National Committee to Prevent Wrongful Executions, and he's also edited After Prohibition, an Adult Approach to Drug Policies in the 21st Century. Tim's brief points to the relevance of U.S. custodianship rather than U.S. territorial sovereignty. So like Cecilia's brief, he's concerned with the broader issue of the legality of detention centers overseas beyond Guantanamo. After hearing from Tim, I'd like to directly open up a conversation among the speakers and then take questions from the audience.
And like Cecilia, I have colleagues at my office that put pressure on me to dispense with the legalese and try to explain the case in layman's terms, and to do podcast interviews and to try to do that. The case is about a lot of things, but is this on? No. Can you hear me now? Yes. Okay, thanks. The case is about a lot of things, obviously. To me, though, it's primarily about two things. When you boil it down, it is about the power of government to put a person in prison. And secondly, it is about a power clash among our three branches about their role within habeas corpus litigation. The Bush administration has tried to get around habeas corpus in a variety of ways. You've already heard some of them. Some of them is in their legal arguments about non-citizens overseas just do not have rights or protections under the Constitution. But the second way, or at least one other way in which they get around habeas corpus, one that I don't think gets enough attention, is simply their raw exercise of power over the prisoners, where they go. Let me give you two examples of this. One here in the United States is the way they've handled the Jose Padilla case. This is the guy, you may recall, who was arrested in Chicago, and he was alleged to be the dirty bomber. He was arrested at O'Hare Airport, and then he was moved from Chicago to New York on a material witness warrant. And then 2 weeks later, when there was going to be a court hearing on that warrant, on the eve before that hearing, they did two things. They moved him again from New York down to South Carolina, and then they moved him from the civilian court system into the military system, where he was held in a military brig incommunicado. So then habeas corpus litigation had to start all over again, challenging his imprisonment there, and litigated at the district court level, Court of Appeals level, and then they filed a writ of certiorari at the Supreme Court. And just when it looked, this took a number of years, and he's held in prison. And just as it looked like the Supreme Court was going to grant cert and resolve this enemy combatant controversy of Americans here in the United States, the government moved him again. They moved him from South Carolina suddenly down to Florida and moved him out of the military system into the civilian court system and charged him with crimes. So their argument to the Supreme Court was that his imprisonment is moot now. There's no controversy anymore. He's not being held as an enemy combatant anymore. Now he's being charged with crimes in federal court. This is what his attorneys wanted all along. So there's no controversy here anymore. So you see what I mean about moving people around in civilian court system, out of the military court system, and back again. And then a lot of us were wondering, as that criminal trial went on, where's the limit to this power? What if the criminal trial's not going the way the government wanted? Are they going to move him back out and declare him an enemy combatant again and back into the military brig? When is all of this going to end? Let me give you a second example. There was a terrorism trial here in northern Virginia a few years ago where a guy was on trial for terrorism charges, and this is regular civilian court, but he wanted to have witnesses at his trial that he thought would aid his defense, but these witnesses were in the custody of the government, also designated as enemy combatants and held overseas. And he said that these witnesses would be valuable to his case in defending against these charges by the government. And this just wasn't a bare assertion on his part. He convinced the district court judge that these witnesses were necessary and could really aid his defense. The government's response was, we're not going to make these witnesses available at his trial for reasons of national security. Now, the district court responded to this by saying, okay, I hear you about national security, but make the prisoners available for depositions by the defense counsel with all necessary security precautions. And we'll take the depositions, and then we'll use the depositions when the criminal trial gets underway. And the government's response to that was that, no, we're not going to make them available for depositions either. And this went up to the Court of Appeals, and the government argued that, well, this district court, these witnesses that the prisoner is asking for, they're in the custody of the military, and they're held overseas. And they said that the district court just does not have jurisdiction over these prisoners. Their writs, the writ of habeas corpus for this testimony, does not extend overseas and does not extend to non-citizens who are overseas. And the Court of Appeals came back and said, you know that's ordinarily true, that the writs or power of the district court normally does not go overseas, does not go to non-citizens. But they're missing the critical element in this case, and that is that the U.S. government has these people in custody. So it's not just see a subpoena to somebody who's over in Pakistan somewhere. The critical difference was that these people are in the custody of the U.S. government. They have control over them, and their writs do run to the custodian, the government who's controlling them, the Secretary of Defense. So I think that was an important precedent, and this is a point that we emphasized in our brief, because, again, the argument coming from the government in this case is that the writs of habeas corpus, the touchstone of habeas corpus in the government's view is territoriality. It applies here in the United States, but because Guantanamo is, offshore, the writ doesn't go there because it's abroad. And so they keep emphasizing this concept of territoriality. I think that's mistaken. They do have that Eisentrager case from 1950 that stresses that point. But we were arguing in our brief that that precedent was wrong, that territoriality is not the touchstone of habeas. It's this idea that who is controlling the prisoner is the touchstone of habeas, the custodian. There's some cases out there that say who has the power of control over the prisoners. That's the key, because the habeas writ runs to the jailer, not to the prisoner. The writ of habeas corpus is served on the jailer. And if the court is convinced that a wrong has been made, that the prisoner is innocent, the writ runs to the jailer to release his grasp over the prisoner. So this is what we're stressing in our brief, and I took a little bit more away from the oral arguments than Cecilia did, because I was kind of pleased by the way the arguments were going on this point. Justice Scalia was emphasizing, and obviously the Solicitor General of the United States was emphasizing this concept of territoriality, but many of the justices came back to this point about, well, who controls the prisoners? That's the key point. So I was somewhat pleased with that, and I'm anxious to see how the ruling comes down on these points.
Thank you, everyone. I hear a couple of questions coming out of this whole series of comments. One is, what would be so wrong with having the D.C. Circuit actually, especially given, as Ketanji described, the extremity, the enormity of the problem with the CSRTs. If it's torture that's at issue, why can't the D.C. Circuit use the DTA to find these standards and procedures unconstitutional? That's one question that I hear. And another is, Paul and David, in both your briefs, you both point to the way that 9 days after Hamdi was decided, the Department of Defense promulgated a new definition of enemy combatant, which wasn't approved, signed off by the Hamdi plurality opinion, and created a broad definition of enemy combatant, which actually encompasses all sorts of completely civilian conditions that people could be seized in. And did the court take you up on that? And how does that affect what the D.C. Circuit could do with the DTA process?
Actually, I think in some sense those two questions are related. So, by the way, before I go on, I want to recognize Julian Mortensen, who's in the audience, who is also on the briefing team for Boumediene, and was sending me emails at alarmingly late hours over the last few months. So, I think that there are a couple of ways of looking at kinds of claims that someone could bring to the D.C. Circuit. I mean, we've argued that this definition of enemy combatant that the Department of Defense cooked up a few days after Hamdi is way overbroad, and it bears no relationship to what the traditional law of war recognizes as enemy combatants, and therefore people who are subject to military control and the laws of war, as opposed to civilians who are under different regimes altogether. And it's easy to say, and I think that General Clement was trying to say today, look, that's just a legal argument, and the D.C. Circuit is perfectly capable of determining whether that legal argument is correct or not, and so there's no reason to have habeas corpus, traditional habeas corpus, because they can make that argument, and that's in the briefs. The problem is it really isn't that simple, and the problem is that even if the government's definition is right, we still think that our people are innocent factually, and even if our definition is right, and I'm saying our meaning generally, the government may think that some of our people are still guilty. Or I'm using innocent and guilty, obviously in a non-technical sense. So it's just not the case that all of these issues are turning on kind of legal, kind of yes/no answers. And that being the case, it's just impossible for me to see how a limited DTA review of a limited CSRT process is going to be adequate to sort of to examine all these issues in a proper way. I mean, there are lots of people at Guantanamo who say, I didn't do anything wrong. I don't know why I'm here. There are people who, if you would just tell me why you think I'm here, then maybe I can find some evidence that will answer your question. But first of all, you won't tell me why you think I'm here, because you've only allowed me to see the unclassified charges, which are extremely uninformative. I can't see any of the classified reasons for why you think I'm here, so I'm basically guessing. I don't even know what evidence I would present that would convince you that I'm not a terrorist, other than for me to say I'm not a terrorist. So, the CSRT says, okay, well, that's very interesting, but we can't do anything about that, and okay, we declare you an enemy combatant. So then, and mind you, of course, no lawyer in the process, right? I mean, and not even no lawyer. I mean, we're not talking about Miranda or Sixth Amendment right to appoint a lawyer. I mean, we are talking about prohibited from having a lawyer, which is really, I cannot think of any system of justice of any kind in the Anglo-American world where the government says to you, okay, not only will we not pay for a lawyer for you, which is common, but we prohibit you from going out and getting a lawyer to help you, and not just be there standing you, but actually sort of help advise you. Forget about having a lawyer actually stand up and make argument. I mean, you can't even communicate with a lawyer. So the guy is completely at sea. No lawyer, no idea what the charges are really, brought against you. The CSRT says, okay, well, you haven't, given us anything to indicate that you're not a terrorist. Oh, and by the way, the government's evidence is presumed to be, valuable and persuasive and so forth. So, how else are they going to come out? If you balance something against zero, one against zero, you're going to, And so then, now you get to go to the D.C. Circuit, and now all of a sudden you're supposed to persuade the D.C. Circuit that the administrative record doesn't support what the government has done. But in doing so, you can't, that evidence that you might, now you get a lawyer. Okay, and now your lawyer, you can get cleared counsel. So far the government has, agreed to that, after many long fights. And now your lawyer can go out and do an investigation and try and figure out, what might be exculpatory evidence. But there's no way for any of that evidence ever to get into the record, because the record is closed. I mean, it's like, the government says, well, this is judicial review and administrative record. I mean, it's like this was a railroad rate-making case, or how much should sugar tariffs be, or something like that. I mean, it's just, that really is their vision of, like, we have this administrative agency, we've developed this record, it's closed, and now you have to persuade the court that, some error was made. But how do you do it? That's what is just so that's what, to me, is, you can look at the DTA and you could maybe, through some very aggressive interpretations, fix a lot of the other problems. And General Clement conceded some of those today, like the fact that the DTA doesn't authorize the court actually to order anybody released. He sort of gave that away today. There are some other problems that are kind of at the margin. You'd have to kind of do some aggressive interpretation. But I've yet to figure out how this problem can be fixed. And that, I think, is really, in some sense, the kind of the fatal flaw.
I agree with that, and I would add, I think there's also the practical problem, which clearly troubled a number of the justices today, and they raised it, which is, habeas is supposed to be a speedy remedy. Well, the first DTA petition was filed 2 years ago. The D.C. Circuit has not even ruled definitively on some of the preliminary questions about how the DTA process is supposed to work. The one ruling that the D.C. Circuit did make, which was to say that the record on appeal should be the record that's defined in the very regulations that the government came up with, something called government information, which the government regulations themselves define as all information reasonably available to the government regarding the detainee. So you would think, okay, that's the government's own regulations, that's the logical record for review. The government had argued for a much narrower record. The government argued the only thing that the court should review is the evidence that was actually put in front of the CSRT, so that if there was this much evidence reasonably available to the government, but the government only put this much evidence in front of the CSRT, that's all that the D.C. Circuit was supposed to look at. Now, even the D.C. Circuit couldn't buy onto that one. So they said, no, what you have to show us is this. The government filed a petition for rehearing that made two, to me, absolutely extraordinary claims. Number one is they said, if you make us do this, it will destroy our nation's national security. And they had affidavits from the head of the CIA and the FBI and the National Security Advisor and I think maybe President Bush's mother. But and their second argument was sort of even more extraordinary. It was, we never kept the goddamn records, and you'd have to make us go back and reassemble that, and that will bring the government to its knees because we'll have to have hundreds of people around actually collecting the evidence. It was obvious that when they did these CSRTs, it never occurred to them that they might ever have to be called to account and come before a court and present it. So that, it's basically the dog ate our homework, and you shouldn't make us redo the homework. The D.C. Circuit, it's hard not to get upset about this, but the D.C. Circuit, so in the petition for review, and again, when we're talking about a speedy remedy, when did the government file its petition for rehearing? Months ago?
Yeah.
We are still waiting for the D.C. Circuit, the goddamn D.C. Circuit, to issue a decision on the petition for rehearing in bank. This has been 4 months. And the panel, at least, did issue a petition for a denial of the petition for rehearing by the panel. But this was a Pyrrhic victory for the detainees as well, because what the D.C. Circuit, it didn't say something like, are you kidding me that you didn't keep the record? We're holding you all in contempt. No, it was, well, gee, here's our solution. If you really can't find the record, why don't you just go back and hold another CSRT, 6 years later, and present whatever evidence you want to consider by then, and we'll look at that. I mean, some of the justices were clearly troubled by that. And I would say, the idea that now, after this kind of 2 years of dicking around, that somehow that we get sent back to the D.C. Circuit so that they could dick around for another 4 years is absurd. And I just don't think, and this is where I think one of the things that's sticking in Justice Kennedy's craw, and one of the reasons why I think he will rule in our favor, because in between the time that he joined the justices in denying cert and the time that he ruled to grant it, one of the things that happened was some of these absurd arguments that the government's making about what they can and can't do under the DTA, and I believe that had to upset Justice Kennedy and make him think enough is enough. I'm not going to make these petitioners exhaust clearly inadequate remedies.
I would just add, I think that's right, and I would just add that, why can't the D.C. Circuit fix the problem? If you look at the statute, it doesn't just say CSRT proceedings happened and the D.C. Circuit can review them in whatever way it wants to. The statute has very specific limitations on what the D.C. Circuit is allowed to look at and do. And I think that's the D.C. Circuit could conceivably at some point interpret the statute in such a way as to broaden its authority. But it's pretty difficult, as Paul said, given that the statute says, the scope of review is limited to these two areas. So it's hard to see how the D.C. Circuit would really go about fixing the problem.
Yeah, the government's vision is let's say the D.C. Circuit reverses. They send it, then the result is, okay, well now government, start over. You get a new CSRT. Mm-hmm. So the government does a new inadequate CSRT, and you petition for review, and the D.C. Circuit says, sorry, it's wrong. Start over. You get a new CSRT. It's kind of it's really kind of this endless loop. And, I was sitting there thinking, see, what do I have on my calendar for 2009? When is this, when is this, next brief?
Bob Schiff, can we have the mics up? Thanks.
First of all, thank you for doing this. I was lucky enough to be in the courtroom this morning, and I've been on a high all day long because it was just such an extraordinary demonstration of advocacy. And so you've allowed me to continue the high, the natural high, for another few hours, augmented by a glass of wine. So it's really great. And I wanted to quickly just relate that the gentleman over here who moved the admission of his mother, Matthew, I think your name was, he was immediately preceded by someone else who moved the admission of his father. So apparently this ploy is getting around.
Not unknown.
And it will be interesting to see if the court ever cracks down on it, but I hope not, because it's a wonderful thing. I wanted to ask you to just relate a little bit more about the argument, if I could. I agree that Seth Waxman's rebuttal was just extraordinary. And Paul touched on it a little bit in his the answer to the last question about the juxtaposition that Seth was making between what happens when you have a lawyer and the ability to present evidence of your innocence and what happens when you don't. But perhaps, Paul, you can give a little bit more detail about the two cases that Seth talked about and how he worked that into a rebuttal to one of the issues that the court had been concerned about. And then, secondly, there was this extraordinary continued debate between Justice Scalia and Seth Waxman on the jurisdictional question. And Seth kept on trying to come up with cases that would satisfy Justice Scalia's question of, show me a single case where a court either here or anywhere else has ever said there's habeas jurisdiction for a non-citizen outside of the territory of the sovereign. And so one of you who was there, maybe, I think people would find it interesting. It was they kept on going back, and Seth would say, let me give that one more try. Let me have a few other cases that I can try to convince you with Justice Scalia. It was really a wonderful partner.
Trying to persuade Justice Scalia, I think in some sense can be a hopeless endeavor. And, you might as well, one can sort of, there have been times when I've said, look, I'll just concede your vote, and let me talk to the 8 others. I mean, it's interesting. I mean, a lot of the briefs, what Bob is referring to is, the assumption is that what the Constitution guarantees is for habeas corpus is what existed in 1789. Now, first of all, if you don't, I mean, we sort of assumed, we've sort of been willing to fight the battle on that turf. It's not, you don't necessarily have to buy that premise. That is, you can, and I wish this had come out a little bit more in argument, but, you can also say, that you don't have to actually point to a case a specific case that is exactly like yours before 1789 in order to convince the court that it's protected by the Constitution. But we were willing to kind of, play on those terms. And there are the essence of what Justice Scalia was trying to say, and sort of what the government has been arguing, is that habeas corpus at common law, to the extent that it protected persons who were not subjects, who were not, well, it's not, the citizen is not the concept, but not English, let's say, or not persons who were also subjects of the Crown of England, that the habeas only reached within the English, within the domains that were sovereign authority of England. So not just England itself, but also sovereign English possessions, or so the Channel Islands, the Isle of Man, the American colonies, the various little, specks all over the globe. It did not run to places like Scotland, which, although habeas corpus did not run to places like Scotland, which, although was in union with the Crown of Great Britain, was never subject to English. It was not subject to English law, and indeed still is not. So it was England and all of England's, colonies out there. And so the government has always tried to say, look, that's as far as habeas went, and Guantanamo is not like that. Yes, it reaches the United States, it reaches Puerto Rico, it reaches, American Samoa, it reaches Guam, but it doesn't reach any place outside of that. It doesn't reach places that are not our sovereign territory. The problem is when you look at this, more closely, it is just not that simple. And there indeed are a whole series of cases where judges in where British judges sitting in India, when India was under the kind of the joint control of the British East India Company and the local authorities, Indian princes and so forth, British judges were sitting there issuing habeas corpus, and not only to British people, but to Indians. And so, like, what more do you need, really? Well, that wasn't enough for Justice Scalia. He had to show a judge sitting in London, issuing the habeas corpus, going all the way to, someone in India and saying, let him loose. I mean, clearly he was not ever going to buy the argument. But it's also the case, there's lots of case law from the British colonial period saying what really matters is not whether the Crown has sovereign territory, but whether these people are just subject to us. And Guantanamo is entirely subject to American rule. There is no other writ that runs there other than the writ of the United States. So that was, I think, what that was going on. I frankly think that Justice Scalia was fighting a losing battle, on that ground, and he sort of fought that in Rasul, and he lost it. And I think it's very hard to believe that the court is going to reverse its course there. On the other point, I might let somebody else have a reaction, but what Seth was pointing out was a very, very real world example of where somebody who, when he was in his CSRT proceeding, had absolutely no way. The government, said basically, well, I can't remember the exact details, but you're a terrorist, and part of the basis that we think you're a terrorist is you have this connection to this guy who was killed himself in a suicide bombing, and because of that, you're a terrorist, and end of story. Well, once he filed a habeas corpus petition and got a lawyer, he found out that this person who supposedly, blew himself up in the suicide bombing, as a terrorist, was like not only not a terrorist, but was, alive and well, and living in Germany and pursuing his. He had probably a name that was very similar to somebody else's, or it was misinformation or whatever. But it just goes to show how, when you have no access to lawyer, compulsory process, or anything, mistakes can happen, and they happen. Anybody who's worked in, kind of the, in the details of the criminal justice process, for example, as Ketanji and Cecilia have, mistakes happen all the time, and that's what our, engine of justice depends on, cross-examinations, compulsory process, and so forth. I mean, they're not perfect, but they're sure a lot better than not having them.
Right.
If I may, I'm Jim Oldham on the Georgetown Law Faculty, and this is in connection with the question that was just asked. I had the honor to be counsel of record on the amicus brief of legal historians in this case, and the India question is really an interesting one because we developed the research that generated that argument to the court, and I unfortunately had to teach a class this morning, so I couldn't be with Matt and his mom at the hearing itself. But as I understand it, Scalia was pressing Seth about the India cases and was saying, but look, the Indian courts were established by charter, and since they were established by charter, that meant that they were essentially statutorily authorized to do everything an English judge could do, and that meant that they could issue the writ of habeas corpus, and therefore all these India cases don't matter. But it seems to me that's hocus pocus, because the English authority that was extended to the Indian judges was to administer the law in the way that English judges would have administered the law, which included the common law, which included the writ of habeas corpus, which then extended to wherever there was a colony or, as you say, these odd locations like the Channel Islands or the little community called Berwick and others. So I don't think that's going to be a winning argument, at least I hope not.
Oh, he's got a response to that, but, we won't.
And I have two quick questions. The first one, goes to the comment Mr. Cinnamon made that I think cuts across not only this case, although I think this is a wonderful example, but virtually every case I've ever seen, criminal, civil, corporate, and that is that the judiciary and the judicial rules tell us, for example, you only have so many days to file for rehearing en banc. If you don't file it on time, you're out of luck. And then those courts, including the retired judges, so I would kind of hope they might themselves express some agreement, can sit on something like this that's a habeas corpus for as long as they want with no end at all. And I think this is a perfect case to either suggest that the Supreme Court, as the top of the judicial branch of government, should do something about it. In fact, if a district court sat on a case like this, we'd go to the Court of Appeals and ask for mandamus. And I wonder if anybody thought about asking the Supreme Court not to allow them to do that. If this is, it is as outrageous as I can imagine, or alternatively, of going to the legislature and saying there should be a limit. And there's many executive proceedings where if the government doesn't deny something within so many days, it's presumed to have denied it, and force the judges to simply take their vote and tell us the outcome, even if an opinion is to follow later. And so I think this is a wonderful case for that, and I don't know if it was discussed or thought about, but I certainly hope it was, at least that it crossed somebody's mind. The second point that I'd like to ask that crosses my mind, and I'm afraid I'm showing my age, is that I realize back in the 80s when President Carter allowed Cubans to come here who were Marielitos, and many came from Cuban prisons. At least we thought they did, because he sent them without records. They were incarcerated in many what were then military bases across the U.S. because we didn't know what to do with them. And many were paroled out, many wound up back in prison. In fact, I know, at least I believe, there's still a couple hundred in Atlanta Federal Penitentiary from that time way back in the 80s. And my recollection is that when their case went up to the Supreme Court, it was based on an immigration record, because they had had immigration hearings and they went directly to the courts of appeals from those. And I thought in those immigration hearings, as was mentioned about these military commission hearings, that the rules of hearsay didn't apply, that there was no presumption of innocence, that if they didn't testify, it could be used, their silence could be used against them, and all the same things that are missing from here, not all, but many of the same things. Like you said, is this a rate-making proceeding? Well, those sort of look the same, and I wondered whether that analogy and discussion of that either came up in any of the briefs or at oral argument.
Can I make a response to the first one?
Yes, please.
On the first point about the speediness, as I mentioned, a number of the justices were clearly concerned about that. In fact, even I think, for example, Chief Justice Roberts, who's not sympathetic to us, was trying to help General Clement figure out how to explain the lack of speediness in a way that wouldn't affect the cases. But General Clement obviously was sensitive to it, and what he suggested at one point was, well, this court can take care of the speedy remedy problem because you could affirm the decision below, but then remand to the D.C. Circuit with instructions that they should expedite their decision. And the justices jumped all over him, including Kennedy, said, well, what do you mean? If we affirm, we have no jurisdiction. I think Justice Kennedy said, what are we supposed to do, tell the D.C. Circuit, have a nice day? So Clement did try to suggest that maybe the way you could resolve this problem is to tell the lower courts to move quickly. But again, the justices were saying that's inconsistent with his basic argument, which is the courts have no jurisdiction to do anything. And I think there are answers to that, but I think Clement was shaken a little bit and didn't really give the kind of answer the answer he could. The other point I want to comment to underscore what you're talking about here is the Maminian and Alota cases that are before the Supreme Court were argued to the D.C. Circuit in 2005. 2005. The case then sat there before that panel in the D.C. Circuit while Congress, the judges waited for Congress to pass the DTA, then called for supplemental briefing on whether the DTA stripped them of the jurisdiction, not only briefing but argument. That occurred in 2006. Then the D.C. Circuit sat and waited for the Supreme Court to decide Hamden to determine whether this jurisdiction would be stripped. When the Supreme Court said, no, you still have jurisdiction, The panel still continued to sit there waiting for Congress to pull the irons out of the fire, which Congress did in the MCA in the fall of 2006. So by the end of the beginning of 2007, the beginning of this year, the case had been sitting there 2 years after oral argument. And we in the Allo case did something that I've never done before with the court, and some of our colleagues in the other cases were a little concerned about it politically, but we felt we had nothing to lose. We basically filed a motion to expedite decision. And the essence of the motion pretty much said this, as bluntly as, your job as judges is to decide cases. Decide the goddamn case. Now the decision came out a few weeks after our motion. I'm not suggesting that there was a cause and effect relationship, but we just...
Be careful what you move.
Yes. Yeah, exactly. Well, we knew with the panel we had, we were going to lose anyway, so we figured let's get the decision so we could get up to the Supreme Court. But I mean, you are correct that I think it's an endemic problem that, in fairness to judges, it's hard, I think, especially when you're sitting in an appellate court, to always think about the fact that, especially in criminal cases, they're human beings sitting in this. But I think this case is probably, Justin, you can probably comment about this. This is just really a particularly egregious example of people who have been imprisoned indefinitely in maximum security, situation where you'd normally put the most hardened murderers and criminals, never having any hearing or anything else, and they're just sitting there while the courts the courts and the President and Congress go through, I don't know if it was Seth or somebody has described as the world's slowest moving chess game. And it's a travesty in the basic issues of justice.
On the second question, did anybody discuss the immigration?
Well, I think, in the immigration context, I don't know what's happening these days with the Mariel Cubans from the 80s, but the Supreme Court actually did say in the Zadvitas case from, several terms ago, that when the executive branch is detaining someone for immigration purposes, it is limited to immigration purposes. And when someone, like the petitioner in the Zadvitas case, cannot be deported from the United States, in that case he was a guy who was stateless, so there's no country that would take him, there's a due process limit on how long the government can detain. So if you're detaining someone as an immigration agency, then you can only detain them to get rid of them. And so, the court has been willing in those cases to put limits on the detention. And moreover, in the immigration context, although my main job at the ACLU is to challenge procedures often, with respect to the immigration process, and we're often pointing out the constitutional deficiencies there, you do have a right to counsel. You don't have a right to appointed counsel at government expense, but you have a right to counsel. And, the rules of evidence and other things don't apply exactly as they do in criminal cases. For example, there's no exclusionary rule except under regulation under some modified circumstances. But compared to what's happening at Guantanamo, the immigration process really is a lot closer to what we're used to in criminal cases.
Right. And your lawyer can go out and find evidence.
Right. You're allowed to present your evidence.
Hello, I've done that in immigration immigration proceedings. We had like a whole search of people, and one client of mine, in his home country, and found lots of evidence, and presented it, and it was all in affidavit form, but the judge accepted it and so forth. There's really no way to do that in the CSRTs.
I think the evidentiary point is an interesting one because it sort of highlights one of the things that we struggled with in our brief early on, that when you look at this entire scenario, there are so many levels of outrage in terms of what is happening over there that you have to kind of figure out, well, what are we going to attack? Right. And I think at one point there was some concern about the rules of evidence not applying, but there are other circumstances in which the rules of evidence don't apply. And so you can't really just say, oh, well, the rules of evidence don't apply, so therefore it's not an adequate substitute for habeas. And I think the one thing that our constituency was able to coalesce around was that even in 1789, under the common law, courts were not allowed to rely on torture evidence. And so that one aspect of it, I think we were able to really get, some unanimity around the fact that to the extent that this process allows such evidence to be introduced, that is really problematic given our Anglo-American tradition, in the way that maybe even certain other aspects of the process, isn't quite as problematic.
Not just because torture is bad, but also because you can't rely on evidence.
Correct, because it is unreliable evidence, and that has been, historically established. And so for the CSRTs to, and in some cases, there was an example that we had in our brief where the allegedly coerced statements of the detainee was the only evidence. That was it that the CSRT had against this individual, who has now subsequently been released, but had been held for years based on his own statements that he said were coerced from torture in Pakistan and Egypt. And the CSRT said, very interesting, we think you're credible, we will refer your torture allegations to another authority to pursue, and oh, by the way, we consider you to be an enemy combatant based on those statements. And that apparently routinely occurred in the context of the CSRTs. So, our judges felt very strongly that to the extent that that was the basis for judging a person an enemy combatant, that the process was improper.
My name is Lene Erickson. I'm with Alliance for Justice, and I have a practical question. If, as you predict and others have, that Supreme Court sides with the detainees, and of course I hope that, what is the practical effect for the detainees? Is this just another piece of the chess game? May the administration just move the detainees to another place that's not Guantanamo, perhaps Bagram Air Force Base? May Congress just pass another law that has slightly different protections and not the exact same ones, and then we end up in the same place? Or is this the end? I hope.
That's probably anyone's guess. Number one, I think I'm pretty confident in saying that this Congress will not pull the administration's chestnuts out of the fire again. The Democrats are pusillanimous, but they're not that pusillanimous. And so I think that that the administration would not be able to return to Congress again to try to reverse the Supreme Court. My concern, again, goes back to the delay. It's quite possible, I think, that there won't be a decision in this case until the end of the term. That's June 30. We're into the 7th year of detention. Then the cases go back to the district court. Under the best of circumstances, the cases go back to the district court. One of the things that Paul and I didn't even really have a chance to touch on is the question of, in their brief and our brief, we argued that not only should the court reverse the court below on this jurisdictional question, but it really needs to reach the merits, which the D.C. Circuit never did because it concluded it didn't have jurisdiction. One of our concerns is it would be another Pyrrhic victory for the Supreme Court to say, yes, the MCA is unconstitutional, there is jurisdiction. Now we're remanding to the D.C. Circuit to decide the question that was appealed to the D.C. Circuit in 2005, which is whether in habeas hearings the detainees have any rights. Under the best of circumstances, let's assume the absolute best of circumstances. Let's assume we get an early decision, say in March. And let's say that the court actually does what we asked to do, which is reach the question on the merits and say not only do we have jurisdiction, but these folks are entitled to habeas hearings in which they're actually allowed to go forward and present evidence. Then you would hope that over the course of 2008, those hearings would be held. The silver lining to me is I firmly believe that the administration knows that 90% of these cases, if they were held to the light of day, won't be able to stand up to anything. That's why I think that the pace of repatriations has increased markedly in the last 6 months. And I believe if the Supreme Court comes out our way, I think you'll see Guantanamo emptied out pretty quickly, except for a fairly small number of people. That may be wishful thinking, but I think not.
And I think, the question was an interesting one. I mentioned 2 ACLU cases where we've got people who were tortured in places other than Guantanamo, in Iraq and Afghanistan, and CIA black sites in other third countries. And I think, even if the government doesn't move the current detainees to a place other than Guantanamo, because that would create some political heat, I imagine, in the future, when the U.S. is capturing people or accepting people, captured by bounty hunters or whomever, where are they going to put them and what is going to happen to them there? And I think, really the principle that there are some violations that are so egregious that the Constitution has to reach them is one that that really has to survive whatever comes out of the Supreme Court in this case. And, I think Tim was mentioning that there was some comfort to be taken from the argument today in the discussion. Seth, I think, very ably started talking about how, at Guantanamo, no other law applies. Right, and that's a key thing. That's a key factor to consider. But it's not just in Guantanamo that circumstance can arise. In Iraq, when we invaded and the coalition provisional authority took over, which was really U.S. run, one of the provisions was that the U.S. military shall be immune from all process in Iraq, in the Iraqi courts or the Iraqi justice system. And so it's really something we should be concerned about. If not for these particular detainees in these cases in the Supreme Court, then as a matter of the rule of law. There have to be limits on the abuses that U.S. government officers can engage in wherever they happen. Whether the Constitution applies in any given case might depend on a lot of things, including practical considerations. But at the outer limits, there has to be some kind of backstop.
The worst part of my job is ending conversations that are going well. I promised that the panel would end on time, and so I'm holding myself to that. But I'm not cutting off the conversation. Please feel free to speak with the panelists as they're snacking. They're vulnerable when they're snacking, so come chat with them. And of course, I hope that these conversations will percolate beyond. Once again, please join me in thanking all of the panelists.